You are welcome to class. Today we want to look at this topic, law of contract. I want to examine first nature and classification of contract. Now let us define a contract. A contract is a legally binding and enforceable agreement. A contract is a legally binding and enforceable contract. Contract between parties. So it is a legally binding and enforceable contract between parties. That is a contract, an agreement which a court must recognize as affecting the legal rights and duties of parties to it. So where people or two people are coming together to enter into a particular agreement and they intend that they are entering into a legal relation, okay, or they intend that court must enforce the agreement. So that is a contract. They are not just coming together to just agree without having a particular purpose. So that means that what they are agreeing upon under contract must be fulfilled. Parties must fulfill their promises under the contract, and any party that fails to fulfill his own promise must pay for it. So that is what we mean by a contract. So it is a legally binding agreement and it must be enforced. That is, if a party, aggrieved party, take the matter to court, then the court will enforce the contract. So it is a purpose of enforcement. That is why it is called a contract. Not just ordinary agreement, but an agreement that the court must recognize. So that is a contract. And also we have what we call consensus addendum. This consensus addendum means meetings of mind. Meetings of mind. That means that minds coming together. The two minds, the minds of the party, is not only by what they are saying, okay, by either what they have written down or what they are saying with their mouth, but also their mind must follow whatever they are saying. That means that whenever they are agreeing on a particular thing, their mind, there must be an agreement through words or through written document, and also through the mind. So the mind of the parties must agree together. That means that what Mr. A intends to sell is what Mr. B also intends to buy. So that is what we call meetings of mind. The agreement must have meeting of mind before such an agreement will be enforced. So every agreement, every contract is a product of agreement. So that means that people must come together to agree. Then in the process of their agreement, then they will have it in mind as they are agreeing that they intend to enter into a legal relation. So now let us look at the classification of contract. So we have so many classifications. So number one, the first classification is what is known as express or implied contract, where a contract is oral, is made orally or in written, or it is written. Okay. If a contract is written or is made orally, so that is express contract. So, and also implied contract means that it's not in oral form, it's not in a written form, but it is inferred or discovered or known from the conduct of the parties. It may be through the way the parties, their they have been behaving towards each other. So that is what we mean by conduct of the party, the way they have been behaving towards each other, or maybe even through the custom of the particular issue they are dealing with, or the particular business they are dealing with. So that is what we mean by conduct of the parties. Then number 2, another classification, bilateral and unilateral contract. A bilateral contract involves contract between parties, okay? And then the promise is also coming from the two parties. Take for example, we have party A, party B. So party A is promising to sell a particular car to party B, and party B also is promising to pay some amount of money. That means that each of them is exchanging a promise. So promise is coming from A to B, and promise also is coming from B to A. That is bilateral contract. The unilateral contract is a contract in which it is only one party that is to fulfill its own promise. The other party may promise, and they may not even after promising, it may not even fulfill the promise. But the general rule is this. Now, under unilateral contract, party A, where party A is promising party B, then the contract is binding on party A, okay, to fulfill its promise to party B, but nothing is binding on party B. So the exchange of promise is only A that is giving promise. There is no any exchange. So party A is only the one promising to do a particular thing, while party B is free whether to do anything or not to do. So that is what it means by unilateral contract, where promise to do a particular thing is coming from a party, while the other party is free. And also we have what we call formal, number 3, formal and informal contract. A formal contract is a contract under seal, okay, signed and sealed. So it must be written, it must be signed. So we have the condition, written, signed and sealed. So it must be written, signed by the parties, and sealed. Another name for formal contract is called special contract. Special contract. So it must be in written form. Whereas informal contract, another name for informal contract is called simple contract. And this contract can be in any form. It may be in oral form, it may be in written form. So there is no any particular form which it must appear. So it is only formal contract that must be signed, must be written, must be signed, and must be under seal. So, but in informal contract, it can be in any form, either in oral form or in written form. It may not even be signed or be so that's what we call informal contract or simple contract. But in simple contract, parties must exchange promises. Any party that does not exchange promise cannot enforce the contract. Whereas in special contract or formal contract, in formal contract, a party may fulfill his own side, while the other party may even not promise anything. So, but the contract is binding on any party that has given a promise, okay? And the other party that does not or has not even given any promise can at the same time sue the other party that has given promise to fulfill his promise under the contract. So because the contract has been signed, written, signed, and sealed. But under a simple or informal contract, the party that does not furnish consideration cannot enforce the contract, because under informal contract or simple contract, parties must exchange promises. It is a must. It is only a party that has promised to do something that can enforce that can tell the court to compel the other party to fulfill his own side of the bargaining. So that is what we call formal and informal contract. Then let us look at void, voidable, and unenforceable contract. A void contract is a contract that is illegal from the beginning. So void ab initio. That means that it is not only that it is even illegal, it's a contract which the court will not recognize, because right from time, party don't even supposed to enter into such contract. So that is what I mean by it is void. It is unenforceable at all, and it is what the court will not recognize at all. So just take, for example, contract to kill someone. Contract to kill or to kidnap someone. So these are contract to kill, to murder, to kidnap, to do all sorts of evil things are part of what we call void contract. So that means that it is a contract that people don't even supposed to enter. That means that it is not is an illegal right from time. As you are entering into it, you are committing what should not be done, or you are doing what should not be done. That is a void contract. Then voidable contract is a contract that parties can escape liability under. A party that give room to party to escape liability. And such contract, take for example, if someone enter into a contract with an infant, contract with infant. So where someone enter into a contract with infant, the contract is binding on the person, the adult that enter into the contract with infant, but the contract is not binding on the infant, except if it is a contract of necessary. Okay, so and that is why if somebody enter into a contract with an infant, take for example, an adult promise to sell a car to an infant and the infant promise to pay. If the infant means one who is not an adult. So if the infant should refuse to pay and collect the car and refuse to pay as at the time he's supposed to pay, that means that the court cannot compel the infant to pay, because the contract is not enforceable on the infant. So now the infant may pay and the infant may decide not to pay, because if the matter gets to court and the infant raised the issue that at the time he was entering into the contract he was an infant, then the court will not ask the infant or force or compel the infant to pay the money. So that means that the infant may decide to escape liability under the contract. And also contract with the insane person is the same thing. The insane person may get to the court, refuse to fulfill his promise, and also get to the court and tell the court that as at the time he was entering into the contract he was insane, or even a drunken person can also escape liability. So that's what we call voidable contract. An unenforceable contract is a contract that is okay, is perfectly it's okay, there is no, but there are some technical problems. Take for example, contract for the sale of land must be written. That is the law. And where such contract is not written, if there is a problem, what the court will have to do is to tell the parties to return and then go and make the contract to be in written form before returning to the court. So court can enforce the contract or do anything or pronounce anything regarding the contract until such contract is put in a written form. So that is why it will not be enforceable. That is what we call unenforceable contract. Now let us look at joint contract. Now this is a contract made by two or more promisors, that is, okay, who are jointly bound to fulfill their obligation. Now this is what I'm trying to say. Contract made by two or more promisor and also two or more promisees. So that means that it is not only Mr. A, it is not only Mr. A and Mr. B, it could be Mr. A, Mr. B, Mr. C, entering into a contract with Mr. X, Y, Z. So that is what we call joint contract. Now let us go into legal requirement of a valid contract. Now for a contract to be valid, we have what we call legal requirement that must be fulfilled. Number one requirement is offer. And by definition of an offer, we say that an offer is a proposition made by the offeror to another party called the offeree. So now that is what we call this is a proposition, an offer, and that is why for a contract to exist, there has to be an offer by one party to another party. That means that one party making a proposition to the other party. If party A should say that I want to sell my biro I will sell it for 100 naira to you, Mr. B. So that is what we call an offer. So an offer, and also the offeror must state clearly and precisely the time under which the offeree must enter into a contract with him. So that's why we call it the proposition made by the offeror, the person that is offering something, okay, to another party called the offeree. So stating clearly, okay, and precisely, okay, under which he want the other party to enter into a contract with him. So, and also for a proposition to amount to an offer, there are some conditions to be fulfilled. Number one is that it must be definite, certain. So it must be definite and certain. So it must be definite and certain. So that means that whatever Mr. A is talking about, Mr. A must be precise. Mr. A must be certain. If I want to take, for example, if Mr. A wants to sell his biro to Mr. B, Mr. A must be certain about the biro, certain about the price, and everything must be stated clearly. And also, no, another, that means that it must be definite. And also, the such statement, the offeror must also be a person that will be liable, okay? So must have contractual capacity. Mr. A, the offeror, must have a contractual capacity. That means that Mr. A must not be an infant or a drunk person or an insane person. And also it must be communicated. The offer must be communicated. So these are the conditions an offer must be fulfilled. So it must be definite. It must come from somebody that is having contractual capacity, and also it must be communicated to the offeree. So the offeror is the one making the proposition to the offeree. So that is the definition of an offer. Now let's just look at type of offer. We have what we call specific offer, and we have what we call general offer. A specific offer is an offer made to a particular person. If Mr. A should tell Mr. B, I want to sell my biro to you, so it is directed to Mr. B, is specific. If it is general, it is to the whole world, where Mr. A is now telling the whole world, to everybody, maybe through newspaper, TV, or any other form, okay, of communicating to the public that I want to sell his biro. If anybody is interested, he should come. So that is what we call general offer. If a person enters into the class and announces to the student in the class that I want to sell his biro, if anybody that can pay 100 naira to buy the biro should come forward. So that is a general offer to the public. Before, general offer was not recognized until a case came up called Khalil versus Kabulik Small Ball. Khalil versus Kabulik Small Ball. Cool. So in this case, a particular company, this company producing smoke ball for anybody suffering from influenza, and they made an announcement that whoever that partake or use their smoke ball will not suffer influenza, and the plaintiff used the smoke ball and still suffer influenza. The company even said that in the advertisement they are going to pay £100 to anybody who uses their smoke ball and still suffer influenza. So the plaintiff used the smoke ball and suffer influenza and then sued the company to court. That is Kabulik Smoke Ball Company to court. And then when the matter got to court, the company said that they were not making the offer to the plaintiff, that it was an offer made to the whole public and it's not subject to accept and it cannot be accepted. So, but the court held that an offer can be specific and also it can be general. And regarding that, the case before the court said that that offer is a general offer, an offer made to the public, and any member of the public who suffer such influenza after using the smoke ball has automatically entered into the contract with the company, and because of that the company must pay the money. So that is the case of Khalil versus Kabulik Smoke Ball Company.